This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why a criminal's money must stay with the state after they get an order of forfeiture, and that assets forfeited to the state are not subject to attachment. A fraudster's assets are forfeited, and once they are forfeited, they deprive any judgment credit of a right to attach because they no longer belong to the criminal. In BD versus Sussex County Prosecutor's Office, the Superior Court of New Jersey Appellate Division, on April 19, 2024, dealt with the claims of a victim of a sex offender who attempted to get assets of the offender that were forfeited to the state before the victim obtained a judgment. In this declaratory judgment action, plaintiff BD appealed from the Law Division's order dismissing his complaint in which he sought to obtain proceeds forfeited to the Sussex County Prosecutor's Office in a related health insurance fraud case. The facts of the case establish that Troy Leonard, an in-home therapist who treated multiple minors, including the plaintiff, who had attention deficit hyperactivity disorder, autism, and other undiagnosed learning disabilities. Between September of 2015 and November of 2015, while the SCPO investigated Leonard for allegations of sexual assault of minors, it discovered Leonard committed health care insurance fraud between 2014 and 2015. SCPO investigators uncovered multiple bank accounts containing the proceeds of that fraud and determined Leonard purchased 4 vehicles between 2014 and 2015 when the suspected healthcare fraud claims occurred. In 2015, the SCPO obtained an order to seize and restrain those bank accounts, which the court granted. Leonard was arrested and charged with multiple counts of sexual abuse of minors, including the plaintiff, and 38 counts of second-degree health care claims fraud for allegedly billing insurance companies for services he did not render. Altogether, the SCPO seized $610,228.15 and 4 vehicles. The court entered a final judgment by default in favor of the state with title vesting in Sussex County for the property on April 18, 2016. Leonard pleaded guilty in the criminal matter on May of 2016 and entered into a stipulation of settlement pursuant to a plea agreement, agreeing to forfeit the seized property. In 2016, plaintiff's legal guardians initiated a separate civil action against Leonard seeking damages stemming from the sexual abuse. On September 16, 2016, Leonard was convicted of multiple counts of second-degree sexual assault and second-degree health care fraud by a practitioner. Later, a final judgment was issued in plaintiff's favor against Leonard. Plaintiff was awarded $700,000 in compensatory damages and $100,000 in punitive damages. Plaintiff, unable to collect from the prisoner, Mr. Leonard, sued the SCPO for declaratory judgment seeking to satisfy his award from the forfeited proceeds in the amount of the judgment. The trial court concluded plaintiff did not have standing to bring a claim against SCPO for the forfeited proceeds and dismissed his lawsuit. Plaintiff argued he had standing to bring his declaratory judgment claim against defendant SCPO because he had a personal interest in the matter. There is a significant public interest, and there is an actual controversy between the parties. The Appellate Division concluded that plaintiff lacked standing to assert an entitlement to the forfeited proceeds. A plaintiff must have a sufficient stake in the outcome of the litigation, a real adverseness with respect to the subject matter, and there must be substantial likelihood that the plaintiff will suffer harm in the event of an unfavorable decision. The pivotal question before the Appellate Division was whether plaintiff had an interest sufficient to support the declaratory judgment action. Since the final judgment of forfeiture severed all property interests Leonard had in the funds held in the bank accounts and cars months before plaintiff obtained a writ of attachment to Leonard's property on August 5 of 2016, and nearly a year before plaintiff obtained a final judgment in the civil action, Leonard had no funds to attach. A writ of attachment reaches only ascertainable property of the defendant. Here the proceeds were no longer Leonard's property when the writ of attachment issued, and later when final judgment was entered, the final judgment of forfeiture eliminated Leonard's ownership of the money and the vehicles. Therefore, plaintiff had no right to notice of the forfeiture because the final judgment for forfeiture was issued on April 18, 2016, and plaintiff did not file his complaint until July 7 of 2016. In my opinion, the plaintiff is clearly a victim of Mr. Leonard. He obtained a judgment against Leonard. He could attach any property belonging to Leonard. However, Leonard had no property worth attaching, since the state took his property obtained by fraud by forfeiture. There is no question that a fraud perpetrator cannot be allowed to profit from his fraud. Even if his victims were harmed and should be able to collect a judgment, they could only collect from honestly obtained assets. And since the fraudulently obtained assets were properly taken by the state, there was nothing for the poor child who was abused by Mr. Leonard to collect. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can get notice of every blog posting, usually 5, sometimes 6 a week, and you can have access to the more than 4,750 blog posts. You can also subscribe for free to the videos on YouTube and on rumble.com, and if you do, I'd appreciate it if you click on the link on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publication. And please tell your friends and colleagues about the blog and the videos, and let them also subscribe. Thank you for your attention.